In this video blog, I will be discussing the unbundling of legal services, or what may eventually be known as limited legal services. Typically, when individuals retain a lawyer, they will receive comprehensive services. This means that the lawyer will represent the individual in all aspects of their matter until such time that the matter comes to a completion or the solicitor-client relationship is terminated. With the unbundling of legal services, an individual may hire a lawyer for part, but not all of their matter. For example, an individual may hire a lawyer to complete a specific task or provide legal advice regarding a specific portion of their matter without going on the record with the court as the person's lawyer. In 1993, a decision of the Superior Court of Justice, it was held that this relationship is an acceptable one. A lawyer would simply be considered to be the barrister or counsel for the individual, and any appearances before the court or any work completed would not attract the obligations or duties of the solicitor of record. The individual who retains a lawyer for limited legal services is still considered to be his or her own solicitor, as we call it, or lawyer. It is important to note, however, that a lawyer retained for limited legal services would still have the same ethical obligations to the client to provide the same quality legal advice to the individual as would be expected if they were to retain a lawyer for their comprehensive services, subject to the fact that the lawyer's limited retainer may prohibit them from providing the same quality of advice, as they may not have all of the information that they would have had in a comprehensive retainer. This type of limited retainer may very well be the solution to the access to justice dilemma we face in family law in Canada. Unfortunately, many individuals are unable to afford the services of a lawyer, and they're faced with the difficult task of representing themselves. Limited retainers provide access to the justice system to those who wouldn't ordinarily be able to afford it, as they may be able to spend their scarce resources on specific steps in the legal system that they feel they need to have legal representation in. Some disagree with this position, as they believe that the solution to the access to justice problem is an increase in funding provided by the government for programs such as legal aid. In the current economic climate, I don't foresee it being realistic to assume that the government will be able to provide the additional resources required to make legal representation affordable for all. Therefore, why shouldn't individuals retain lawyers on a limited retainer basis and have them complete the work which they do not want to or are unable to complete on their own? These alternative lawyer-client relationships will help many individuals who would have otherwise been left to navigate their way through the legal system on their own. These type of lawyer-client relationships have become very common in the United States and are beginning to gain support in Canada. Although counsel has been able to provide limited legal services since 1993, when the Logan and Logan case was handed down, the Law Society of Upper Canada has recently put a task force in place to investigate this matter further. This task force has come up with proposed amendments to the rules of professional conduct for lawyers to ensure that, if adopted, it would govern the relationships between clients and their lawyers who are not acting as the solicitor of record. At our firm, we are prepared to speak to our potential clients about this option in order to ensure that as many people as possible are given a fair chance to access the justice system which was created for everyone's use.